Hello, everyone. Wanted to welcome everyone to our webinar. Today, we're going to be talking about protecting what you are owed in these turbulent times. We're going to be talking to Emalfarb, who is the founder of National Lien and Bond. He's been in construction law for over 40 years. He authored the Illinois Construction Law, which was published by Matthew Bender. He's a contributing author for the National Construction Law Treatise, specializes in contract termination and modification, and updates mechanics lien laws in all 50 states for his members and clients. He created the first 50-state legal summary from American Subcontractor Association and worked heavily with the National Association of Credit Managers. Also on the call with us today is Jason Katz, who is a Florida board certified construction lawyer and acts as local counsel and lien provider for National Lien and Bond. He's experienced in representing companies in all facets of construction, from contractors, subcontractors, developers to material suppliers. So I'm going to hand it over to Hal to do a quick introduction on what he does.
Anatoly, thank you very much. Anatoly is also a member of the National Association of Home Builders and very active, and certainly encourage all of our viewers to, if they're not already members, to take a look at the National Association of Home Builders. And I want to welcome Jason Katz, a board certified construction lawyer in Florida, in our program today. Since 1986, we have founded a national lien and bond claim system network of attorneys and lien providers and notice furnishers throughout the United States. So we've had quite an experience since that point of time until now, putting together an organization and helping people like you learn how to get paid and incorporate within your organization an internal controls and system for you to be in a position of, let's call it power, but we kind of like reference it a little bit softer because you want to maintain the customer relationship, equalization of your position as a supplier or sub or a GC and owner, so you can at least get fairly what you're entitled to. Today, we're going to have a little bit of providing you with questions and answers, and you'll see as we go through our program, next year, we're going to be giving a program once a month, kind of like a Mechanic Lien Institute forum, helping clients like you and contractors like you provide the opportunity for you to learn more and more about this most valuable tool. The mechanic lien was actually created in similar uncertain economic times as we're experiencing now. Those times were then called, in 1791, the establishment of the United States of America and the Constitution. And in the Constitution, it provided for 10 square miles, which today we know is the District of Columbia. When that act was created, forming the District of Columbia, there was no Republic of the United States. There wasn't a national organization. There were 13 states. Two of those states at that time in 1791, Virginia and Maryland, put together state legislative action, created the 10 square miles, and within that language, the Act of Maryland included those parties providing materials and services and labor to a house or a building would be entitled to a lien. It was about a page and a half. Today's mechanic lien laws, there's 50 of them for private jobs, 50 of them for payment bond claims, and about 27 of them for public lien on funds. Plus, we look at the Federal Miller Act as a remedy. So you have all those acts, none of them are a page and a half anymore. So today we're going to kind of give you the overview of what a mechanic lien act looks like generally. And then we're very fortunate to have Jason here today as a board certified construction lawyer in Florida, because Florida is a really good example of a state which provides protection for subs and suppliers and contractors against scrupulous developers and lenders. Not to say there's a lot of them out there, but lately they seem to be popping up a lot like popcorn, okay? So we decided we would put this program on to help, and any questions and answers or chat, Anatoly will be able to filter out the information, and hopefully we'll either be able to get a hold of the answers today as we talk, or we'll certainly get back to you. National Lien and Bond has a passion because all of its members, our office in Chicago, Emalfarb, Swan and Bain, is general counsel since it was founded, and all the lien providers like Jason and the notice providers, the best in the country, we have a passion. We want you to protect yourself by understanding what your rights are and taking those steps to get you paid. So on many projects, as you know, it's risky. Not every one, thank goodness, but a lot of them, they're there. What today's program is really all about is putting you into a position that you will be feeling that you're prepared and that you've planned for the worst and we hope for the best. So today we're going to be discussing how to protect your largest asset. And we're going to be asking questions today. Like one question is, and you'll find out, I hope, the answer, and I think it applies to most, if not all of you, what is your company's largest asset? Other questions that we'll be exploring today is when you're extending credit to customers, are you doing such on a secured or unsecured basis? Before you start work, are you requesting a project data sheet from your customer so you have a little bit of information? Like many times, some of our clients, for example, equipment crane rental companies, they're pretty far removed from the job. They're working for a sub or a sub-sub, so they don't even know who the general contractor is many times. So they want to know, or you want to know every time, the information. And we'll be looking quickly at what a project data sheet looks like. Do you know all the steps required in your state to enforce your lien rights? Well, now you have a resource with people like Jason and our notice services and our firm that work together to provide a platform called mechanicsLien.com that is there to answer your questions generally. We don't answer questions online legally because that's something you would do with lawyers or you would be working with a notice service to do your work. But what we do provide you is at least a working knowledge of the statutory scheme of your mechanic lien on private work, public work, and federal work. So obviously the laws that apply, except for federal, which applies to all 50 states, is the state of the project. So of course, the question we ask you is what project is your state located in? The next question we would ask to get answers, is it private, public, or federal work? Then what is your role? And you'll see why in a little bit, why your role at the job is going to make a difference. And one of the main questions people ask, do I need a notice on every project? So the first step in our project is really what we consider to be a project data sheet. And we think that the answer to these questions start by filling the information out. So we're kind of in the process, because we've been having a debate nationally as to whether or not we should have this completely cloud-based or continue doing what we've been doing for over 40 years, manually filling out project data sheet forms. So we're in the process, as you'll see, of transitioning our customer base and our member base to the cloud. But right now I'm going to show you for one second, what does a project data sheet look like? So here's the National Lien and Bond, original and still in operation for many of our users, project data or claim data sheet. So it comes from you. You basically fill out your contract information here. You identify the states of what your project is and the kind of job it is. You describe your products, your contract date, your information, what type of job, number 5, your first and last dates of work, and then you start talking about the project. What is the project name? Who's the owner, the contractor, the sub? Of course, your customer, your credit information, and then most importantly, number 12, your status. And you'll learn why, because some people are covered here when they fill this out, and some people aren't. And is the project, like we asked earlier, private, public, or federal? And in doing this, it helps us understand what's going on. Jason's going to talk about the project notices, and in Florida particularly, it's not true in every state, but Florida is a good example of a notice of commencement and how that relates to your project. And then, of course, besides liens, we have bonds in all public jobs of a certain size, all federal jobs, and thank goodness, as you'll hear from one of the stories that Jason and I worked on together, a payment bond on a commercial job. Then besides your customer in the GC, we want to know other people that you feel are going to be important on the project. And what our customers basically do here is they create a situation where once they fill the form out, you'll see it's relatively simple to get the information you need on a particular project. So as we start to answer the questions, one thing that we're going to be kind of referring to, Jason and I together, is recently, and we're still in the mix of this on this project, one of our clients is an electrical sub in the Southeast, was working on a Florida job. And Jason and I have been working together for many, many years. How NLB through our office selects Counsel comes from lawyers that we know, recommendations, and experience that we've had. And Jason, for example, really impressed me so much on this project. I was really glad we were able to turn I believe, and we are turning the leverage around where the general contractor told one of our clients, an electrical sub, on a project, which many of you would work on something similar to this, and that would be a multi-family apartment building. And on that particular building, the general contractor also was a partner with the developer. And our client, don't ask me why, because when we got called by the client, it was 3 or 4 months of construction draws that they weren't paid. But they wanted to finish the job. And as you'll see in other seminars and programs, when you terminate a construction job or walk off, there's a lot of risk. So this particular client, a national electrical contractor, decided to finish the job, do its work, act in good faith, and not leave the job unfinished where the GC would terminate him and backcharge him all his money. So for 4 or 5 months, our client never got paid a draw. One of the things we'll be talking about today a little bit and more in our program next year on the Mechanical Lien Institute series is when do you suspend work and when do you walk off on the job? So on this particular job, our client was owed about $500,000 on a contract and about $200,000 in what we call extra delay conditions that were extended. When the client was finished, and the contractor's been claiming that we've delayed the job. So Jason's going to talk a little bit about what we discovered about how we believe we're going to help the subcontractor get around the delay claims and prevail, not only by taking the steps we did to file the notice, which Jason will talk about, and the lien, but also what the substantive is of Florida law that's protecting subcontractors when a general contractor claims that they're going to backcharge us. I don't know if any of you are experiencing this lately, but I'm seeing this almost every day nationwide. What our office does is our clients come to us as members of NLB, and once we kind of help work with them on all phases. The first phase is the compliance, which are what is your time periods and notices, then the client's performing the job, then they get paid. We seldom hear from them. We're told to close the file, or if something comes up like it did here, they'll contact us. And then we team up nationwide with our notice providers and our local counsel, or we call them co-counsel, such as Jason. And it'll be a very interesting set of facts and legal application that Jason will explain to everybody here today. What we're basically looking for is to create a situation for you to understand. For 40 years, we developed a kind of like a formula. And I think it's important for you to protect your biggest asset, which is, we believe, your receivables. And if you add up the value of your receivables compared to every other asset, you'll see the total of your receivables is usually gigantic. The payment of that money that comes from the receivable basically is your cash flow. So how do you protect your cash flow as an asset and keep your business flowing so you can pay your bills and profit as an owner? So our formula is based on a concept. And the concept is transaction, which is your contract, plus power, which are your legal rights and your performance rights, equals payment. So we want you to know that formula as we go through here, because the lien is not by itself. It has to fit into your business model and your day-to-day operations. So your staff and you, and it's pretty hard today since everything's remote, is to try to keep all of this together. So it all starts with a project data sheet. It goes on with transaction plus power equals payment. And then we kind of talk about the things that help you calculate, and Jason's going to give you an example of the steps and deadlines of a Florida project, and how you can minimize your risks by understanding not only your contract and what provisions exist and how they are important, because those terms and the legal application, as you'll learn from our conversation with Jason today, will show you how we were able to, again, turn, we hope, the conversation around where the general contractor says, you're getting nothing and you owe me money. And we did all the work. Okay. So as we go through here, keep in mind your role on the job is important. And the reason for that is it defines your notices. So if you take, for example, a general contractor, they're always covered by lien laws. And generally, they don't have to provide notices, a general, because they have a contract. They're in privity with the owner. A subcontractor is not in privity with the owner, and typically they are required to provide notices. Then a supplier or a sub-sub, they're required to provide notices as well. In many states, you're covered by the mechanical lien or bond claim law, no matter what tier you're on. You're a supplier to a supplier, sub to a sub, sub to a sub-sub, whatever. Now, in many states, you're not covered. And an example of that would be in the federal construction is the Miller Act. A sub to a GC is covered and a sub to a sub is covered. A supplier to a supplier is not covered. So you have to know in your state and in your type of project, private, public, or federal, what the statutory schemes are. And we help you, if you're in one state or 50 states, understand that scheme. And if you need help and support, we can provide that information to you. So our role as general counsel is to work with you to make sure you have that formula of transaction plus power equals payment to provide you with the protection of your biggest asset, your receivable. Our job is to separate legal fact from fantasy, and we'll be showing you a little bit today about how that process works, and more importantly, what the substantive law is, particularly in Florida. Now, many of you are in Florida, many of you are not in Florida. I really urge you to listen to Jason's presentation to understand the specifics, as he'll outline the specific steps to go forward. Now, one of the questions I asked before, and I like, if you can, I don't know, Anatoly, how it's going to work on Zoom exactly, technically, but there's a chat or some sort of like question and answers. My question I would ask all of you, are you, when you're extending credit in construction to your customer, do you believe today that you're a secured creditor or an unsecured creditor? And if you can respond back in the next couple of seconds, you know, I would appreciate that just to get everybody's feedback, because I want to see what your understanding of that is. The questions that we're going to be talking about today is, when you're defining your role, you have to understand your position. Are you a general or a sub? So the example I just gave, and we'll continue with that throughout our presentation, Jason and I a little bit, refer back to it, is the general contractor here also is a partner with the developer. So is our client a sub to a GC, or a sub to, or basically a prime contractor, because the general and the owner are basically one and the same. It's called a one entity theory, where they're jointly participating. Many times developers have their own general contractor company as kind of like an in-house group. So they're really the same people. Other factors that are going to be important: what work of yours is lienable? Can you lien for late charges, and how much more? What is your last date of work? Those are questions that we'll be discussing a little bit or going over. What if all the funds have been dispersed? Can I make the owner pay twice? And will my lien survive bankruptcy? So in answering these questions, everything is kind of based on basically the elements of a lien. And the elements of a lien are basically a valid contract, you furnish lienable services, you complete performance or have a valid excuse for your non-performance, and you complied with the statutory steps that we're going to be talking about. So as we do this, there's some legal things that come up, but let me just mention that the steps in every state are very specific. And as we begin to answer the question, are you a secured creditor or unsecured creditor, one thing that I would like you to consider as we go through this process is that you're basically in a situation where you're extending credit, and you're extending credit for a lot of money. And we talked about, again, in our example, why would a subcontractor, and it's a little mysterious to us as counsel, continue to be working when they're not getting paid month after month after month? And these are the kind of situations that people get into that you may need a little help in getting yourself some advice nationwide or in your state of how to protect yourself. So these are questions that we want you to be looking for the answers today, and we'll be using this as an example and some other situations as well. So let me introduce Jason, and as he's going to talk, the exact rules and laws of Florida won't necessarily apply unless you're in Florida or working in Florida in your state. But I don't want you to feel that you're not going to get the information, because every one of you will get from us either a 50 state access to laws in time periods of 50 states, or in your particular state for every project that's either private, public, or federal. So Jason, let me turn this over to you now, and then we'll continue, hopefully be responding with your questions and answers about whether or not you're a secured creditor or unsecured. as you extend credit in construction.
We've been getting a lot of those answers, and so far the consensus seems to be that unsecured is the way to go. Not the way to go, but everyone feels like they're an unsecured creditor.
There's another question that I used to ask really quick, Anthony. It's kind of funny. You'll be surprised by the answer when we get to it a little later. But I would also say this: if you see how everybody's dressed on this Zoom, Anatoly, Jason, and I, it would be like Anatoly looks like the subcontractor, Jason looks like the developer, and I look like the general contractor, all dressed up. Okay, and here's the subcontractor, kind of just the average person actually doing all the work and doing all the performance. So I used to be able to tell how everybody would be when they would come to a workshop back in the 1980s and 90s when they'd be dressed. Today it's a whole different world, so it's kind of hard to separate all those parties out. But okay, Jason, let's talk a little bit about what your role is with NLB and how Florida law works.
Sure, thank you, Hal. Thanks for the introduction. So I've had the pleasure to be working with National Lien and Bond, helping to secure the rights of contractors, subcontractors, material suppliers, and Hal gave a great story about one of our subcontractors that we're currently working through now. So let me just put the PowerPoint up briefly, but it's not going to just be information. We're going to kind of have some war stories as we go along here. Let's see.
And just while Jason's pulling that up, if anybody has any questions, please use the Q&A. I am monitoring it and trying to respond as we go along. And then at the end, we'll also have a Q&A session where we could ask these questions to Hal and Jason.
Right, so I'm going to talk to you a little bit about construction liens. Let's see, oh, I passed it. All right, so the National Lien and Bond, the claim data sheet is great. It gives us great information, everything we need to know for a lien to get the ball rolling, right? So if you have a simple project where you did work for $200,000, you're still owed $50,000, and there's no real hiccups, that claim data sheet gives us everything we need to know and get started here. So just a word, this is Chapter 713 of Florida statutes. Hal earlier was telling you about how the lien law has evolved from a couple pages to many pages. And in Florida specifically, which is where I practice, that couldn't be more true. It's a very complicated, involved statute. It's a pure creature of statute. It needs to be strictly construed. So if you're not following it to a T, then you could be out of luck, which is why it's always good to get lawyers and services involved in helping you perfect your rights under the lien law. So, like, for instance, in the situation that Hal was talking about, we had, we got the claim data sheet, but we had to go dig deeper into the claim data sheet because in that situation, we had the electrical subcontractor who was owed a lot of money, but they were also asking for money which they have a right to under the contract for change orders, and beyond change orders there were delays and inefficiencies, there were claims. So we had to go in and see what is lienable and what is not lienable. And we had to go through a lot of the claim was in the change orders. So what we had to do was go through, all the client's documentation, go through the change orders. We had to evaluate, what the general contractor's claims against this electrical subcontractor were, to see if there was any valid reason to reduce our claim of lien. And really, that's where we got into the meat and potatoes of this thing. Is in going through the change orders, we learned that our client was owed the amount of money that they were saying, that the contractor had in fact extended the duration of the project through these change orders. So the claims for delay were not accurate. We had gotten close to 4 months of additional time through the issuance of these change orders. And even after the substantial completion date, we found that the owner and contractor were still ordering additional changes to the work. So there's kind of nuances there where if a subcontractor is claimed late and the contractor is asking you to perform different or additional work after the substantial completion date, then they need to give you more time to do that work. Otherwise, they could be waiving the time is of the essence provision in their contract. So we have to look at all of these things that are way beyond the claim data form to make a determination as to what kind of lien rights do we have, if at all, and what we should be leaning for, what we should not be leaning for. And I will tell you a little bit later on in this presentation is, if you include something, anything that shouldn't be in there, it could cause your lien to become a fraudulent lien. And if there's a lien that's a fraudulent lien, then there's a complete defense to the entire lien. So if you have $1 million lien and $999,000 is good, but $1,000 was in there fraudulently, then you could risk losing your $1 million lien. So it's really important to make sure that what we're doing here within the lien law, and this is just Florida, by the way, anything I'm saying is relating to Florida. There's likely other similar statutes in other states, but that's not my world, so I can only speak about Florida at this time. So we need to make sure that our lien includes only the items that should be included in the lien, and we go through that process. We go through the claim data form. So let's go through the process. The initial process is preliminary notice, which is the notice to owner. So if you're a general contractor working directly for the owner knows about you, so you don't have to do, you don't have to send a notice to owner. Okay. If you are a subcontractor or another lienor, then you have to do your notice to owner, and that's basically putting the owner on notice that you're out there working on the job, and that anytime the owner goes to pay the general contractor, he needs to think about you. And so Hal was mentioning those folks that have lien rights and those folks that don't have lien rights. In Florida, lien rights are given to the prime contractor, subcontractors, subcontractors, but not subcontractors, right? So it ends there. And it also goes in, gives rights to laborers or material men who contract with a sub or a sub or the general contractor. But it doesn't protect suppliers to suppliers. So you got to make sure you have lien rights to begin with, and then you go from there. So when you guys fill out the form, the bond form, the lien and bond form, we take a look and make sure, is this person a lienor? Okay, they are. Have they done the preliminary notice, the notice to owner? And that has to be done in Florida within 45 days from the first date of work. So the first date of providing labor, services, or materials. And it has to actually be received by the owner within that time, unless you've sent it within 40 days. So there's always nuances. It's a very complicated code. There are lots of exceptions. There are lots of rules. There are lots of specifics. And it's my job to know them. So when a form comes to me and we want to make sure that we're doing everything right, we say, we make sure that the preliminary notice has gone out.
Jason, can you talk about the notice of commencement? What is that, and what is the purpose of that?
Right. So the notice of commencement. Let me go to the next slide, which talks about the notice of commencement. So when we do our notice to owners and we do our liens and we prepare liens, then in Florida, the notice of commencement is like the construction project Bible. Okay, we can go to it, we can look at it for everything that we need. It tells you who the owner is. Okay, so sometimes it's these single purpose entities that you don't know who the owner is. Sometimes the owner is not the owner of the property at all, but a tenant. So it could be a leasehold interest, and the notice of commencement is going to tell you, who owns if the owner is a leasehold interest, and actually who owns the fee interest, who is the landlord, who owns the real property. It'll tell you who the general contractor is, because if you're a subcontractor, you may only know who your customer is, and you may not know who the general contractor is. The notice of commencement will tell you if there's a bond on the project. on public projects, and there's mandatory bonds, but on private projects, there can also be bonds, and the notice of commencement is where you look. And one very critical item about the notice of commencement is that if you record a construction lien while the notice of commencement is active, the lien will relate back to the recording of the notice of commencement. So what that means is a notice of commencement lasts by default for 1 year from the date of recording, and that can be amended and changed. It could be any amount of time. It should be the amount of time the project's going to take or expected to take. So if you go out there and you say, okay, I'm going to go start working on a project, and I see there's a mortgage, I see there's some financing, but I'm comfortable that there's equity in this project. I'm going to extend credit like Hal was talking about. I'm going to do this work with the expectation that I'm going to get paid. But if I don't get paid, I need to secure my interests with lien rights. So you go ahead, you start working, and if someone comes along and starts loaning money to this owner, there may not be any equity. The good news is that you can start working on this project because when you lien, your lien will relate back to the notice of commencement, which, hopefully you've done your diligence and you can see that it predated any new mortgage, any sale of property. It's really there to protect you. So you get to go back in time and pretend as though your lien has priority as of the date of the notice of commencement. And that's very important.
And Jason, quick question for you. There's a couple of questions that have popped up here.
Yeah.
One of them is, can you remind us what a notice of commencement is?
Okay, very good. Sorry about that. A notice of commencement is a document that the owner swears to and records in the public record. So it's like an affidavit from the owner, where the owner is telling you everything that you're entitled to rely on about this project. There's a little spot in the top that lists the permit number. It lists who all the players are, the owner, the contractor, the lender, and it's sworn to. And it tells you if there's any sureties on the job. So that is a requirement of every project in the state of Florida, that a notice of commencement be recorded prior to construction of the work.
And then, thank you, Jason, for that. And then another question is, if the start date is delayed, is it required to resubmit an NTO?
No, there is a timeliness factor of when a project should be started. It is possible you can file an amended notice, but it really depends how long the delay is. So those are real specifics, and the code does speak to it in chapter 713.13 is where you'd find all the information you want to know about notices of commencement. So after a certain amount of time, yes, you should do you should amend your notice. And if you believe your project is running long, so for instance, if it was set to expire after a year and you say, okay, this project has increased in scope or things are not going as planned, then you can always file an amended notice, which extends the completion date.
Jason, we just had a couple weeks ago, a concrete contractor who was working on a project. It was another apartment building, I think it was a condo in Florida. And in that situation, the lenders changed in between. And they released the first notice commencement, and they put on a new notice commencement. And then you told us, which we did another notice of furnishing by our notice company, and that protected them at that point.
Correct. So yeah, Hal's right. So weird things happen all the time in construction projects. In this one, I believe there was either a change of a lender or a new lender came in. And because of what I told you about how a lien relates back in time, the new lender said, whoa, look at all this construction going on. I don't want to be second to all these contractors as the lender. Lender says, I need to be first. So what's the solution to being first if the notice of commencement predates the recording of the new mortgage? So what happened was they terminated the notice of commencement. They asked all of the lienors to provide final releases, which we had to work with on the language to resolve these releases. And then what happens is then the loan comes and files their mortgage, and then they do a new notice of commencement. And when that happens, you have to file a new notice to owner. And those are the kind of little nuances in Florida law that we can, help our clients with to make sure that they're fully protected, because you don't want to give a release and be done, and not have rights later on. 6 months from now, if our clients owed money for the work that they'd done, we want to make sure that they were fully protected. So they did the right thing. They got us involved at the time that the lender was coming in and asking for us to release our claims and issue a new notice of commencement, and we were able to help them.
This detail that you're mentioning is confusing, and you can even fall asleep sometimes listening to it all, okay? But it's so important. And the fact that you are able to have that kind of experience provided, of course, ourselves as general counsel for years, that confidence, because, while maybe like boring and can get mushed up with everyday life, particularly now with what everybody's got so much on their mind due to the pandemic and so on, and the economy and the risks that are out there. But if you forget about these details, you wish you had them before. So the key really here is that we as an organization aren't as individuals as strong or as beneficial as the team of everybody together. Jason's experience really impresses me, and I've been around for many, many years, managing these type of matters, probably tens of thousands in my whole lifetime. It sounds like a lot, but it's one a day, that we deal with stuff. So it's not, it adds up because you get to be older, everything adds up. I look back, if you're a younger lawyer, a younger person listening to this today, you wonder where your life is. I can kind of tell you a little bit, and so people in my generation, what our lives were, because we've lived through them, okay? It's shocking what happens. So having really good people around you with experience helps you get through everyday's life's obstacles and challenges. And Jason's details that he's providing here, really, it's a $9 million contract we were dealing with. Our client was very concerned. It's a large condominium, I think, in Florida. And think about this right now. The markets are really down. Interest rates are very low. Why wouldn't a developer want to refinance his building in Florida to go from 6% down to 3% today? So they're doing that a lot, and there's a trend for that happening. So when that happens around the country, you've got to know where you stand, because that's a risk that could be helping you because the lender gets behind you now, the new lender, or they stay ahead of you, back and forth. And we'll hear a little bit more about that. So I just wanted to add that little tidbit in there.
And Hal, quick question for you. As we're talking to Jason, we're talking about Florida laws, and we keep getting questions about, beyond Florida. Where can they find the information on other states? So we have a question from Monica. Well, first of all, it's about the data sheet. Where can she find the data sheet on the internet? And then the second question is, if Jason's specifically speaking of Florida laws, how do we find the information for the state that we live in? And she's from Minnesota.
So the data sheet applies to all 50 states. It's kind of like we created this 20, 30 years ago, and we're going to have it linked. So pretty soon you'll be able to just get a link of it, and you'll automatically get the information online. Right now, we're just trying to get the bugs out of the system so the information you get is accurate as possible. But I remind everybody, information online is not the same thing as getting a claim sheet filled out, a project file opened up, and getting accurate information after it's reviewed with many of these checklist items and applications of how the law applies to your specific situation. So the general education information that you can provide, each one of you are going to get an invitation, and you'll have all 50 states available to you. And then if you have any questions, you can certainly call us, and then we can engage to the extent necessary our local notice or lien provider to assist you. We also have for you forms that you would need. We have waiver of lien forms in all 50 states and how to use them. So all this information will be available to you at the end of the program. We'll be following up. And of course, there's a phone number. I think on our website, we actually have a phone number, unlike many other websites. So you can certainly call or email us. We actually prefer people to make calls because it's a better way, I think, even though the younger generation of my family and in my office might like to text and do all this kind of stuff. We do like to engage one-on-one to provide you with the information, and we think it's very important.
Sorry, go ahead.
Yeah, no, so don't get frustrated. You should embrace all the information Jason's talking to you about, because I can tell you so far, every issue he's talking about applies to the other state. So if you learn what Jason's talking about, not that you're working in Florida, but the concepts that you need a notice if you're a subcontractor. You need a notice within 45 days of your first day of work. If you send it in the mail on the 45th day, unless it gets delivered, as Jason will tell you, it's not valid. There's a lot of special rules that apply. Then you've got to file your lien, which Jason will explain when, with a certain amount of time, and then you got to file your lawsuit. So those are the steps in every state. A notice if you need it, a claim, and a lawsuit. The specifics are there. Again, don't get frustrated. We have them all. We have Jason's equivalent in every state, including the state that you're in right now, and whatever information you need, we'll give to you. I just didn't think everybody wanted to go through 50 lawyers in an hour and a half listening to it. It's going to be just Jason today talking about Florida, but these examples actually do apply. They're not exactly the same, but they're close enough, and we'll tailor fit your information to you.
And we'll send, after the webinar is done, we're going to circulate both Jason's presentation, the PowerPoint, as well as the data sheet. You'll get that in a follow-up email, and then links to relevant resources for state laws and so forth. Let me ask a couple more questions that we have in here. One is from Narendra. Why is it known as mechanics lien? Shouldn't it be construction related? Just curious.
That's a good question. I think in Florida it is called construction liens.
That's right.
In Illinois it's called mechanics liens.
It was mechanics lien in Florida, and they changed it, I don't know, 20 something years ago to construction liens. But
it's probably because the New York lawyers moved down there or something. I think there's some similarity between the New York lawyers and the Florida lawyers when they took over. Or maybe that's because they knew Donald Trump was coming. I'm just kidding.
Then another question really quick. So if payment is net 60, for example, and the sub won't know that it hasn't been paid yet within 45 days, do you need to send preliminary notice up front before the first invoice?
Jason?
Yes. Yeah. I always send the preliminary notice because you don't know what's going to come. Don't wait to learn that you're not going to get paid before you set it up. So, and Hal's office does a great job at setting up those preliminary notices as well.
Well, Philip, hope that answers your question.
I think it's important for the audience to understand. Not every state and not every law to the kind of questions we're getting applies equally to Jason's. Florida is the strictest law in the country. So if you follow Florida law, you're not going to get into too much trouble because it's the strictest. That's one reason we have Jason in our presentation today coming versus myself in Illinois, where it's a little bit different. So in Florida, just to make sure it's clear, when you start work, you must serve your notice within 45 days of first commencement of work. If you don't do that, you have no lien rights. If you don't do that, you can't do it later. Now, as comparison, in California, if you do a 20-day notice, it relates back, even if you didn't do it right away, to the 20 days before you send your notice. So those are the differences between the states. In Illinois, you don't need to send the notice typically, unless it's residential, which we're not going to get into right now, but typically until 90 days from last date of work. So there's the difference is kind of the range of the notices. 45 days in Florida from first day of work, 20 days from first day of work in California, or relate back 20 days from the work was done, which Florida does not allow, it's strict. In Illinois, 90 days from last day of work. New York is 8 months from last day of work for commercial, 4 months for residential, but guess what? You can wait 7.5 months and you're going to find that the owner paid the GC out in that time while you sat on your rights. Then you get no rights and you can't force an owner to pay twice. Unlike New York, if you follow the steps that Jason's talking about today, in Florida, you will force the owner to pay twice. And that gives you a lot of leverage. And we'll go from there. These are really good questions. I think this is probably, from the questions, the best audience of attendees that we've had ever. And it may be because of the times, or maybe because people are really more informed today. And whatever it is, keep having those questions coming, and we'll continue to answer them.
So one more for Jason, and I'll let you get back into the presentation. But how would you obtain a notice of commencement, and how would a subcontractor know that a new bank is now involved?
Right. All right. So the notices of commencement are recorded in each of the county's official records where the property is, where the project is located. So if we're, in Miami and we're doing a Miami-Dade project, you can go to the Miami-Dade official records and find a copy of the notice of commencement recorded there. You could search by the, it's indexed usually by the owner's name. Anytime we get a lien and bond claim data sheet, that's the first place I go, is I try to find the notice of commencement. If it's not provided, and even if it is provided, I go and look and see if it was amended, because sometimes it can be amended to change the lender. It could be amended to add a bond, a surety bond on there. So that's really the first place you go. If you can't find a notice of commencement because one wasn't recorded, you can, and this is a little bit trickier of a project, but you can go look at the building permit application to find out all the information that you need. So that's kind of second. You don't really want to go doing that because those are with the building departments themselves and not posted publicly. So hopefully there's a notice of commencement and it's recorded correctly and indexed correctly.
And speaking of notices and so forth, Corey's asking a question. Can you still file a lien against an individual's home if there's been no contract signed, but only email correspondence about the project ongoing?
So again, all my answers are Florida related, but an oral contract is a contract that's enforceable under the lien law. So if you had an agreement to go, paint somebody's house and you didn't have it in writing, but they said they agreed to it and they said that they're going to pay you $30,000 to paint their house or $5,000 to paint their house, you can go and record a lien based on that oral contract.
And Hal, do you want to chime in on other states if this applies across the board?
Well, I think Jason explained it correctly. A contract's a contract. It could be in writing or oral. Now, I've been very fortunate because in my 40 years of what was I going to do with my life, and then looking back at what happened, I have experienced other states, all 50 of them. Massachusetts, it must be in writing. That's an exception. However, generally speaking, an oral contract is a contract as long as you perform. So performance is the exception. You'll also hear what happens if the contract requires in writing a change order, and I didn't get a change order in writing. Jason's going to talk about that with our example, a little bit of the law in Florida. So I'm not going to talk exactly about that, but that's an issue. I want to mention something else. Somebody says, this is a mechanics lien or a construction lien. I have to smile because we get a lot of calls for mechanic liens of mechanics, and it's interesting, the people's perception. It begets the question. We didn't answer this specifically, but what is a lien? We didn't answer the question. What is a lien? And that relates to the answer to the question: are you a secured or unsecured creditor? So we're going to talk at the end about what actually is a lien and how that relates to whether you're a secured or unsecured creditor. And then we're talking now more or less what are the statutory steps you need to take in order to get a lien, and what else is out there to assist you, which you'll find out a little bit later. So, this is, to me, these questions, I have answers for it because I've lived through it, but I've got to say something. Every day, I'm shocked and surprised on how much I'm learning every day by people like Jason and the other 49 lawyers and 12 notice providers and our clients, and the questions like this. So keep these questions coming, because it's really a pleasure for us to really see this kind of engagement.
And Hal, you mentioned that Massachusetts is different. In Massachusetts, you need to have a written agreement. And the original question was, while there was no written contract, there are emails exchanged on the topic. So the question is, in Massachusetts, are emails considered a written contract, or does it have to be a more formal contract?
Well, that kind of, I think, would be more of a question of fact to some extent, because when that statute was written, they didn't really have emails, because we all know when emails came up. I'll have to double check with Massachusetts Counsel to find out what they've experienced, or look it up in our research. But my guess would be, if you can establish enough writings, it becomes the evidence of a written agreement. I mean, right now we're working not only in the United States. Strangely, we got a call, I don't know, like a couple of years ago, from a client from Afghanistan, talk about written contracts and what was going on. He was working for a general contractor, a government contractor, that had $500 million of contracts around the world. And on December 31st, 2013, our client, who was an Afghan subcontractor, was working for an American general contractor. The American general contractor wrote the Air Force and said, yes, you asking me, why do I owe this guy money? Because I have no money. I basically am broke. And yes, I owe him the money, and I'm in default. And no, I cannot continue working on your job. But if you want to consider opening a joint account, you can do that. And if you open up a joint account, then quit paying me in my business account and put the money in the joint account. And these were emails that went back and forth. And today we're litigating. I have the pleasure of litigating in the Court of Claims that issue right now with the Department of Justice, arguing that very point, Anatoly. Do the emails, do the communications that represent activities that were performed, create a special relationship. And Judge Wheeler, who just retired from the Court of Claims, sadly, because now we have a new judge, asked me a question. Sir, do you have a contract? Is your client from Afghanistan? I see him sitting here. You have a contract? Thank you for coming. You're in the front row of the Court of Claims. But I have to ask your lawyer a question. Do you have a contract with the United States government? And my client says, no. I said, wait, you can't talk. I have to talk. But my client's right. No, he does not have a contract, Judge, at the time we started the contract. But on December 31st, something happened. And the thing that happened placed our client no longer as a subcontractor. He became what's known as a creditor beneficiary or a third-party beneficiary under the contract between the government and the contractor. So these facts that, like, for example, the attendee here is asking, it has to be looked into. And the answer to that question is still up in the air. So we sued the government, even though we didn't have a contract with him in writing, based on the facts and activities of what went on. So the answer is, under certain circumstances, many of those, you would create a certain kind of legal relationship to either form a contract directly between yourself and the party who's writing the emails, or sometimes you establish a new contract relationship as the job progresses with an owner or GC that becomes a third-party beneficiary arrangement.
So, to build on that a little bit, there's actually a question from Diana. She's from Nevada, asking, as far as public entities, if they do contract work for a general contractor who does work for public entities, how do they file on these projects?
Okay, so I learned a lesson as a young lawyer where I was doing a jail project, a city project, and I leaned it, like Jason mentioned, on the Recorder of Deeds office when I was the only lawyer before I knew better. And the judge says to me, just like the judge in Washington, he goes, Mr. Emalfarb, do you intend to foreclose on the jail and let the criminals out of jail? I go, no, I'm just trying to get my client paid, Your Honor. He goes, well, how do I do that if you have a lien on the building? If you have a lien on the building, you're going to let the criminals out. You're going to have the school children know where to go. The fire department won't have a place. I'm going to have to sell those buildings. And I have the authority to do that. You do not have lien rights on public property. What do I have then, Judge? He goes, do I have to tell you everything? I go, I'm just asking. He goes, lien the funds, you idiot. Okay. I go, okay. So there's in 26 states, you can lien public contract funds, including Illinois, New York. I don't think you allow that in Florida, do you, Jason?
No, the contractors post bonds, surety bonds.
Yeah, well, they post bonds in all 50 states, to your point. And maybe you can mention how that works in Florida, because that works in all 50 states. But to answer Anatoly's question about liens, Nevada, I think you might be able to, because I know you can do it in California, and Nevada sometimes follows it, but I don't remember. So the answer to the attendee's question, Diane, in Nevada, you have a claim against the bond if you're covered, and you do your notices right, and you might have a lien on public improvement funds.
Got it. And Jason, there's a question from John for you. So is a lien invalid at the end of the job if there was no intent to file at the beginning?
So an intent to file is not in Florida, there's no mechanism called an intent to file. It would be the notice to owner that we talked about. And if there is no notice to owner, even if the owner knows about you, like even if the owner is your best friend and you're a subcontractor, if you haven't served the specific document called the notice to owner, which contains all the right language and the statutory warning, then you don't have any lien rights. Correct. If you were required to do that notice to owner within the first 45 days.
Got it. And another couple of questions for you from Sydney. If the property changes hands and the new owner really had nothing to do with any of the original construction agreements, can they still file a lien on that property?
The answer is yes. You can still record a lien because your lien would relate back to your notice of commencement, which was active at the time of your, of the owner that you contracted with. So it would actually relate back in time prior to the transfer. And that's why, you know, when a title company comes in and you want to buy a house or you want to buy a property, they're going to look and see, you know, are there any open notices of commencement? Are there any construction liens on the property? And typically, in order to issue title for the new buyer, they're going to want you to wipe those out.
That makes sense. And then a question from Cynthia, is a notice of commencement followed by a notice of completion when the project is completed? And are all parties that legally prelim the project supposed to be supplied with a copy of the notice of completion? And I mean, she's in California, but let's see how it is in Florida, and then maybe Hal can chime in on California as well.
Right. So in Florida, there is no notice of completion. There's a couple things that can terminate the notice of commencement. One is by operation of its effectiveness. Right on the notice of commencement, it tells you at the, I think it's the last item on there, it says this notice of commencement terminates on such and such date or is effective for X amount of months. And if there is no date, it defaults to 1 year. So after that year, it's ineffective to do anything. There's also a termination of a notice of commencement that one can record. I think it's 713.135 of the Florida statutes, where you know, you have to go through a certain process if you want to terminate the notice of commencement early.
And Hal, you can chime in on this. So the question was from California.
Yeah, there is no notice of commencement in California, but there is a notice of completion. And the notice of completion is circulated once it's recorded, typically by the owner or the general contractor, mainly, I believe, when those parties are in receipt of a notice of furnishing, which is done in California. So remember, I gave the example, California requires a notice like Florida, but 20 days from first day of work, and relates back to the 20 days prior to when it went out to cover you for that work, unlike Florida, that if you don't do it, you're out. But at the end of the job, if you've provided the owner and contractor with a notice of furnishing, then they are obligated to give you a copy of the notice of commencement when it's recorded. And yes, you will hopefully get properly the notice of commencement, because the reason that people do in California the notice of commencement, they shortcut and shorten the time period for which you to file the lien that you're recording. And when you file the lien in California, it's typically 30 days after the job is accepted, or 90 days when the job is completed. So if it's accepted through a notice of completion, then you don't record within 90 days, you have to record within 30 days. So that's an important factor. I've had the privilege in the last few decades of having to, starting with the American Subcontractors Association, the NACM, and other people, manually, and today online, developing the software for the deadlines for many companies around the country that specialize in doing lien calculations. So all these answers we've put together in a database, and we're going to be coming out pretty soon with a really strong legal compliance program that'll answer it. What'll happen there, kind of where these questions are going now, is you'll answer the simple question: what state are you in? Is it private, public, or federal? And are you a GC, sub, supplier? What is your role? And what dates did you work? And so on and so forth. And when you get that, you have what's called an initial review to give you an update that'll help provide and scale up the ability for people to have that information internally. But the answers to the questions and the specifics in every job really need a lot of the thought and an analytical process. And today we see a lot of people doing software, and they're really good at software, and they're pretty good at deadlines, but they're not as good as the person in the state. That's why I caution everybody when I'm speaking to them. While I'm general counsel and I represent a lot of people across the country for doing this and working with excellent lawyers like Jason in notice companies, I always make sure that the answer to the question is coming from the local provider, you know, that we've gotten the information from them. We have a situation today where clients are asking questions about North Carolina. I see that coming in our claim forms. And again, you know, we're talking to California and North Carolina and New York people right now as we're speaking. So, you know, we have the information, not from our heads alone, but from the information of our team. And teaming is really what's making NLB one of the leaders since 1986 till today, working together with people. We look at this very collaboratively because we know that our relationship with you and our counsel has to work well, and you want to have a good relationship with an owner. Later on, if we have time, you'll hear a little frustration, that we're all having out there, because some things, it's like unbelievable what we see happening in trends in the industry today. And if any of you, generally, I don't want to be specific, have any interesting experiences of why people aren't paying, we'd certainly like to know that.
And, there's a couple of actually specific state questions. So one is Illinois, one is Colorado, and one is Florida. So Illinois was a follow-up question to something you had said, Hal. So the notice to owner must be presented within 45 days of commencement, or a lien can't be filed, later. So that's the question number one. Then kind of moving on from there, does that apply across the country, or is that a Florida rule only? John is in Illinois. Also, I don't work for a general contracting company, and I'm typically a subcontractor. I don't know about a job until well after commencement most of the time. Does the notice to owner filed by the GC apply to all subcontractors?
So, okay, Jason explained the Florida law, which again is 45 days from first day of work, 90 days from your last day of work, and then you would file a lawsuit within a year. That's basically the rules of Florida if you're a subcontractor. Illinois is similar in that we have we have 3 steps: a notice, a claim, and a lawsuit, which is pretty much the same in every state. So to answer your question, in Illinois, if you're working for the owner directly, you have 4 months typically to file a lien, and then 2 years to file a lawsuit. If you're a sub, you still have to file a lien in 4 months in 2 years, but you have to give a notice within 90 days from last day of work. If it's a single family residential house, you're required to do an earlier notice, 60 days from first day of work, which is unusual. And if you don't do that, your lien would still be protected if you did the 90-day notice, the 4 months, and the 2 years later on, if the owner still had money. But what we want to do is put you in a position to be as strong as possible, because our formula is transaction plus power, which is compliance with all these rules, equals payment. You have a plan up front, because when something goes wrong, it's like flying. If you don't have the preparation when that emergency happens, you're really gonna be like scrambling, and you're gonna get yourself into a situation that you could have avoided. So that's why we're working together with the industry, and we like this feedback. And pretty soon we're going to be inviting you and other people in the industry to learn more about the NLB Lien Manager program that'll help answer your questions specifically on a job-by-job basis, whether they're private, public, or federal, and what state you're in and what your role and positions are. Because the rules are pretty much the same. The time periods are different, so you have to know your state. And again, don't worry today, right this second, because when we're done with the program, Anatoly is going to send you a link to mechanicslien.com, or you can go there now, and you can find the resources for your particular state that'll give you the information. I think what's important today is take away what the issues are, what the experience are specifically as an example, and compare your state to another state will help you remember how your laws are. That's a good way to really internalize the knowledge of your state, because a lot of people tend to forget because they're not really thinking of your deadlines every day. But that's what we do. We do this full time, and we do it every day. And anytime you do need information, just pick up the phone.
Fantastic. And Jason, question for you. Is an LOI binding, letter of intent? Sometimes these are provided prior to a contract is issued.
Right. So again, that's going to be a real factual issue. If you have a letter of intent and you don't do any work on the project, well, then you don't have to worry about it because you can't lien anyway, right? So you can only lien for the improvements that you make to real property. That's one of the analysis that we do when we get, that's part of the analysis that we do when we get one of these claims in, and they say, oh, well, I have a contract for $100,000. Okay. Did you finish the job? No, I didn't finish the job. Did you do any part of the job? Okay, no, I didn't start the job, but I have a letter of intent. So you might have, depending on what the letter of intent says and whether it can be considered a binding contract, you might have contract rights to something, but you wouldn't have lien rights unless you performed. Now, if you have a letter of intent and you start working, then maybe the facts lean more towards your favor in having a binding contract, right? No one's gonna, someone says, hey, I intend to pay you $100,000. I intend to do your steel work. Steel work starts and then the guy doesn't pay. You know, now the facts might go more in your favor towards having a binding contract where you could actually lien for the work that you did.
Got it. That makes sense. And then, Ken Katz has a good question about, what happens when those lien rights expire. So he installed a sound system and his lien rights have expired. Can he repossess the equipment that is being used in a gym, or is the equipment now theirs?
Right. Yeah, you can't repossess the property, even if your lien rights have expired. Once it's permanently affixed to the real property, it's there, and your rights are your lien rights. So.
Got it. And then the last question here is, Hal, you might not have the answers and might need local counsel, but maybe just kind of high level. In Colorado, are you able to lien on change orders in litigation?
Are you able to lien on change orders in litigation?
Mm-hmm.
What is that? What do you mean?
So it's a question from Ashley. In Colorado, are you able to lien on change orders in litigation?
Oh, yes. Well, of course. I mean, as long as Jason mentioned, we talk about mechanics and construction lien. In all states, it has to be, as Jason said, an improvement to the property. So Jason gave you an example that he and I are working on before, where our client, who's an electrical sub, did the electrical work, the wiring and the fixtures and the controls. And then he also extended the time of his contract. So his contract balance for the hard improvements are $500. His soft cost for his extended overhead and delay in the office and project management, which didn't really add any value to the job, because the scope of the work, let's say, in the situation that is mentioned here by Angela in Colorado, or it's happening in Florida, is the value of the improvement going in. The fact somebody delays it, you can't really lien for delay damages as a change order. But you can ask for that as a contractual change order and enforce that, but you can't always lien for those soft costs. On the other hand, if you have a change order, yes, and you can amend your lawsuit. Let's say, for example, facts came up that you weren't aware of, and you can amend your lawsuit just like a lien to include your claim for contract and add change orders. And whether that will effectively increase the amount of the lien or not for the hard cost is a factual question of how much time is left and what information you put on the lien. Colorado's got actually some of the strongest remedies around. So one of the questions they asked, I think earlier, Anatoly, that we didn't talk too much about, is what happens if you don't have liens anymore? And we did a seminar a couple months ago, as you may recall, on what happens when your lien rights expire. And I think we recorded that, so you can go back to that on the mechanicslien.com website and double check and make sure it's on there, if you don't mind, or again, ask us specifically. But there are many states, I don't think Florida is one of them, and Illinois really isn't either, but New York and Colorado stand out to be very strong, having other remedies. Those remedies are really great. They're called trust funds. Colorado, our lawyer in Colorado, I think his office, I think he's in the Four Corners area. I could be wrong. I just have an affiliation to that part of the world by Durango. So I wanted to be there so I can go visit him. But I guess if he's in Denver or something, I'd still be okay visiting Garden of the Gods or something. But I think that the trust fund laws in Colorado are so strong that, Angela, this person that owes you the money can be shown that he received money or cash from a general contractor, from an owner paid the GC, and the GC didn't pay you, if there's a GC involved, and they took the money, they violated the trust fund laws. If the person who controlled the money filed bankruptcy and the company, neither one of them would be discharged from a debt, because it's actually a criminal law, and you can't be discharged from criminal activity. So we're not going to get into a lot of this today, but one of the reasons we've been around since 1986, in 40 years, is we have a complete understanding of the entire flow of money. So when an owner gets money, he pays it general. There's usually prompt payment of trust fund laws in many states, or the contract that says the general's got to pay the sub, and the sub, the supplier, or the sub within 7 to 14 days. And many of that stuff is labeled under state law right now. And Colorado is one of those states. So if you want us to look for you, we'll ask our Colorado lawyer. He's the person that actually had that law upheld in the bankruptcy court, where people were shocked across the country that how could a general contractor not be able to be discharged in bankruptcy when he stole someone else's money. It was shocking to the general contracting industry that they said, he just said, well, I put the money in the company, but he put money that didn't belong to him. It belonged to the sub. And it was very clear that that's what happened. So, you know, these laws are there to protect you if you use them in advance and on time and get these concepts as part of your daily internal practices. And that's what the project data sheet and all the information we're providing you and the forms that we have will help you do.
And Hal, you know, kind of building on that flow of money and somebody taking something that's not theirs, Maricela asked an interesting question. She's from Arizona. We're a subcontractor and we did the construction work. The prime contractor sent us a payment by wire. However, they sent it to a fraudulent account because a scammer sent them an email pretending to be us. Now the prime doesn't want to pay us. Would a lien have helped in this situation?
For sure. But I think also in that situation, yes, a lien would have helped in that situation because you didn't get paid. And therefore, you know, there's some defenses that may be here because it's got to do with who's liable for the wire transfer. We have some cases similar to that recently in two situations. So the best source of recovery in that situation would be a lien if you have it, because you would still have it in place and you'd be able to be in a position to duke it out. And then the second place would be against the banks that are involved in allowing the transfers of the parties that are unauthorized. So if you need somebody to look at that, we can help you review it if you haven't already.
Perfect. And Jason, you had mentioned that in Florida, you might not need a contract. You know, the work kind of speaks for itself, that if you do the work, then you have your rights. So Adam asked the question, what constitutes work? If I'm working on shop drawings, that can be included, can that be included within the lien, or does it have to be physical work on the job site?
Right. So I guess my point wasn't that you don't need a contract, but an oral contract will suffice. And what do you need in order to lien? If you're a professional, like an engineer preparing shop drawings, and that's your role, then yes, even without an improvement to real property, a professional lienor, like an architect, an engineer, would have the right to lien. Now, if you're a window manufacturer and you're preparing shop drawings, and you never go into production, then no, you wouldn't have lien rights. However, there is an exception for specially fabricated materials. So if you're someone that doesn't go, say you're making custom windows, you prepare your shop drawings, you start production of the windows, and then the job shuts down, you never get to install your windows, you can lien for those specially fabricated materials that you put into production. You just have to separately identify it in your lien. That's a little nuance in the lien law about specially fabricated materials. But I guess the short answer is, if you just do shop drawings and you're not a professional lienor, no. If you are a professional, then yes, you can lien for that.
Jason, I have a question. I have a question on that. In the 45-day notice, the original notice that is required, the preliminary notice, do you have to say that you're supplying specially fabricated goods in the notice or just in the lien claim?
Just in the lien, you separate it out in the lien that you're a specially fabricated material provider, and that it hasn't been incorporated. So if you are a specially fabricated material supplier and you incorporate it, there's no need to differentiate it because you built your windows and you installed your windows. You're done.
Yeah, there's a similar concept in Texas about specially fabricated goods as well, and I think in a few other states. So that's a very good question. And I think it's important to distinguish the different ways. Now in Texas, there is a special fabrication notice that is required, that is distinguished from the other notices. But Florida apparently not. Yeah.
And as far as Florida, Heather's asking, we're going to share the presentation after the webinar, but she's asking also if you'll be sharing the latest statutory forms for Florida, or is that something that she would need to contact NLB for?
Yeah, she could talk to NLB about the statutory forms.
Okay, perfect. Just a couple more questions here. One, it's already been kind of covered, but we can touch on it. Can you file a lien on the property if the customer is not the property owner? Paint job for a customer whose parents are entitled.
In Florida, that's not a good situation to be in. No, you can only, you can only lien the interest of the contracting party. So like we were talking about the landlord-tenant situation, there are ways if you contract with a tenant to get to the landlord and lien that interest. But if you're, if you have a joint, even if you have a joint tenancy and you only contract with one of the joint tenants, then you can only lien that person's interest. There's an exception in Florida if it's husband and wife. If you contract with the husband, you can also lien the wife's interest, but typically you can only lien the interest of the contracting party.
Got it. And Hal, quick question for you. So this, you might need to get local counsel involved, but for California, there's an HVAC contractor did a job on a residential. They installed a new AC unit, were paid by credit card. Customer filed a chargeback, refiled the chargeback, and so forth. In the end, customer got their money back. Contractor couldn't fight the chargeback. Is there anything they can do at this point?
Well, I mean, if you're dealing directly with the owner, you could still file a lien if you're within the statutory time period, which I believe is 90 days. If you're dealing as a subcontractor, you didn't do your notice, then you're not able to take an action. But it sounds to me like you're dealing with the homeowner directly. So this should have taken place, even though it may not have, because going back and forth with the credit card companies, you could be waiting, which again, we don't encourage you to do. And that's why we suggest that you basically blanket your biggest asset of your company with your mechanic lien rights, because those mechanic lien rights in effect create for you an internal compliance program. So like in this situation, if you would delay filing a lien till the 80th day, that would make sense, but don't go beyond the 90th day, because look what happens. Now you have no rights on liens. The fact you don't have liens rights doesn't mean you don't have any rights. You can certainly file either a small claims action, but if you're a corporation, you may need an attorney. Then you file that as a collection matter. And, you provided the services, so you absolutely should be getting paid.
Got it. You're talking about the laws, and I presume that the laws are changing constantly, and they're changing across all 50 states. So a question is, how do you keep the lien laws updated on each state and making sure that you have the most recent?
Well, what we do is we monitor different resources. We're working every day with the notice service and the lawyers in the state. They keep us informed of what's going on, and basically we generally follow legislation as it's going on, because we're interested to see what's happening in the states. And then we have online programs that we kind of watch to go do it. And the industry kind of helps each other, because we're always talking. For example, Anatoly, you're in the National Association of Home Builders. It'd be nice if you talk a little bit what your role is in that organization. And like that organization, particularly in other trade organizations, we work with together to share information, because I happen to have a perspective, as well as other people that are involved nationally in the same area that we are in, that we understand the lien laws. And if people say, for example, why can I do this, or why can't I do that? We have the information from years of experience and the experts that can come in and talk about it. But it's not easy. We do monitor it. And Jason would be telling us in our notice service in Florida and other people, when the laws change, and then we change the requirements frequently. But again, it's not a perfect world. You can't depend on our website as being the end all to be all, as it says on the website. So you've got to make sure that you're actually, if you want to know exactly what's going on, you should be engaging professionals and people that can help you, at the time. And we basically help you if you need it, matching you to a person that knows what's going on, or managing that process for you.
Maybe we could build on that a little bit. So what is a typical relationship in construction between the client, NLB, the local counsel? Kind of walk us through that.
Well, I'll give you an example. Okay. When we first started the program, we had a young attorney that worked with us. He's now the general counsel in a large Fortune 500 company. He called me the other day. He goes, I have to have help here on a lot of these problems I'm having. Well, what's your problem? He goes, we're going to court too much. I go, well, okay. He goes, well, you taught me, and I've brought it to this company, and this is true with our clients that are big, like the Fortune 500, or a family business, that somebody has that they're running. Nobody wants to go to court, and you're pretty good at understanding the concept of transaction plus power equals payment. So I want to really avoid all this action. So the typical relationship that we have is we want you to have your 30, 60, 90 aging sheet or your contract summaries of your subcontracts all secured through the project data sheet with as much compliance as you can provide. And that comes from the contract terms through the lien notices and the steps you need to take. If you're in one state, it's something that people usually handle more or less themselves, and our local counsel notice service, and to the extent necessary ourselves, provide that. For people that work in many states, which are most of our clients, but we do work with local businesses too, then we basically manage the process for them or help them manage it. So the project data sheet comes into our office. For example, let's take a situation that we've been talking about, like the Southeast electrical contractor. He's doing business not in his state, but in Florida. We recognized right away he needed to do a notice. He did a notice. He went to work. He didn't get paid for 5 months. They came back to us, says, we're not getting paid. What do? We then open up a file, and then we do what a typical lawyer would do. We filed a lien claim immediately for him, and we negotiated, and we're in the process of getting him paid through understanding what his process is. And our job is, the attorney that called me yesterday said, look, we like your attitude, because my attitude is open a file, close it, and do the transaction as quickly as possible. As Jason and the other counsel that we work with know. And for the most part, 80 or 90% of all the matters that come in get resolved like that. But unfortunately, and it's very frustrating, we get involved, and more recently than not, ever since general contractors, owners were able to bond over liens, they seem to want to take the money, even though you even lien the job, and not allow you to use your money to get paid, but they take your money and they fight with you mainly for reasons, or a lot of times, that are unjustified, like the situation, Jason, you and I have found ourselves in, and so on. And by coming to us, what we provide is, I personally have a knowledge, because I'm a real estate developer for 40 years. And, I've not done giant projects, but I've done a lot of them. So I understand the process. I know how money flows. And for some reason, I don't know why, I just know where the money is, and whether a client's coming to us from Afghanistan suing the United States government or somewhere else, we look very hard for ways to find exceptions to the law to get in and participate to get you paid. But we rely very heavily. Jason, I'd like you to talk a little bit, the relationship that we have, as I said, began with a project data sheet, opened up a file in our office. We immediately brought you in when we saw what was going on. You helped us with the electrical subcontractor and explained to them what we found on the change orders and so on. This is a situation where we're being accused of delaying the job, aren't we?
Right. So contractor comes in and says, the owner has back charged us for delays, and they're all your fault, subcontractor, electrical subcontractor. And we said, okay, well, we need to explore this. We need to figure out what's going on. We get all the details from our client. They send us their project file, which includes all the change orders. And I think I mentioned earlier, we found in the change orders that the change orders provided us with, nearly 4 months of additional time to perform our work. And these are basically the exact same 4 months that the general contractor is claiming that we delayed the job by. So we throw back them and say, look, these change orders that you signed gave us, a total of 120 days to perform this work. Why are you asserting these back charges against us? And it was a big surprise to the contractor's attorney. He had no idea. It was, he got caught red-handed, and it totally changed the tide of our negotiations. And we sent them another letter with other change orders that didn't give more time, but were issued after the substantial completion date. And we said, the law here in Florida is that you waive time is of the essence provisions in your contract, meaning you can't hold us liable for delay damages if you've issued additional work after the substantial completion date and didn't change the substantial completion date. Meaning, if someone, if your project delivery date is December 31st, you can't come ask me to do additional work in January of the following year and still say that I had to comply by December 31st. So we threw that at them. And then we noticed that there was some kind of common identity between the owner and the contractor. And it all seemed too fishy that the owner was asserting these back charges against the contractor where there was some kind of relationship between them. So what we did is we established these 3 points we pushed it back on the contractor, and we're in the midst of trying to resolve it based on, you know, the change in position. Because when we first got it, they sent us a schedule and it looked like we were pretty late. But once we started digging into everything that happened, it changed the course of the negotiations and gave us a lot of leverage.
Well, you know, what was interesting about what you had just said, because we were both involved in the process together when we teamed up to fight for our client. Our client himself, the executives that we were working with, had no idea that that change order was even there that you just mentioned. We found that when we requested the client to give us all the documents, and clients go, why do you need all this information? This is the very reason why we do. So if you look at the project data sheet that we have, in the beginning, you don't have the change orders because just with the contract. But in Florida, you would have possibly the notice of commencement, if they did a notice of furnishing or not, the contract, the information on the job, the basic information. But then when we get the file again, we ask the clients, hey, we also need from you all the billings, all the correspondence that are relevant to these issues, and the change orders. And then when you went through it, because you were going through the documents as part of our work, it was interesting when you called me up and said, do you realize that the general contractor is claiming we should have been done like in April, and they gave us a change order in June and said, we are now extending not only the dollar amount, but the contract date from April until June, and it was signed by them. And then what did they tell us when we confronted them?
Right, they said it was a mistake, that was just a typographical error, and we had no idea that we changed the completion date. It was unintentional.
Yeah, so of course they had no idea, because they already at that point in time, back to your point, as we discovered, went ahead, paid the owner, which they're partners, $300,000 of our money for delay damages, then charged us another $400,000 for their damages as a general contractor, all based on a document that contradicts everything they just did. Because somehow, by the grace of God or whatever, we were able to find this little detail, you know, that nobody else knew. Our client didn't know he had it, the executives, because our project manager changed hands, so the new one didn't know and the executives didn't know, and the general contractor didn't know. But we, with our passion to figure out what are we going to do, okay, discovered a little fact that we felt was important on that. So thank you for locating.
Yeah,
that,
right.
and that's the kind of work that we do together and team up. And you know, let me Anatoly, I think we're kind of getting to the end of the program. Mm-hmm. So if anybody has questions of Jason or myself or Anatoly or anything that you need help on, yes, any information you need, we'll generally be able to provide to you as a courtesy, because National Lien Bond and this Mechanic Lien Institute is here for one reason, as you're learning. If you haven't known about us before, we've been around since 1986, and we have a passion, as you can tell, to get our subs and suppliers and generals, to the extent we allow them to enter our offices, you know, get paid. And in doing that, I think what's important is we have to answer the question that I think we started with. Are you, as most of you said, you're not a secured or unsecured creditor? You think you're unsecured. The truth of the matter is, yes, you start out in some cases always as an unsecured creditor in industry. For example, if you weren't in construction and you sold goods, how you get a lien, which gets back to the question we haven't answered yet, what is a lien, whether it's a mechanics lien or a construction lien? A lien is a hold on real estate, just like a mortgage. But on a mortgage or in regular business, for you to get a lien on someone's real estate, you have to give them a signed mortgage, granting them a security interest in your real estate or your personal property. The same thing would be true if you're a bank and they make you a loan. They don't have a lien until you give them an agreement and you sign the lien. So you have to convey the lien rights in a business situation. Because of the 1791 law that was established, the first lien law that gave you a lien, not by contract, but by law or by statute. That difference is very fundamental for you to understand. So all of you are theoretically, in the beginning, granted a lien or a security interest in the property by statute. So you have to follow the law and the steps of the statute, an example of which Jason provided in Florida, and you'll get from us in the information that you're going to be able to look up on our resources. When you are able to follow the statute, you do not need the other side to grant you a lien. You get it as a matter of operation of law. So thank you, founders, Thomas Jefferson, and all those people, Alexander Hamilton that created our country, because when they did the United States federal city, what's a federal city? It's the only city in the country that's really a federal city. It's located between Maryland and Virginia, but it's on federal property. It was a celebration in 1791 that occurred in Philadelphia, which at that point was the country's capital. No, they did a whole parade celebrating the formation of the federal government and the federal city that was coming 10 years later. And they celebrated that by giving you in the industry the operational rights by law of a mechanic lien. Why did they do that? Because their economy and their politics was as crazy as ours today. And they wanted you to feel secure when you built something in a federal city, you could actually, on private property, collect by enforcing a lien. So from then till now, the law has been growing and evolving. We're tracking and monitoring with great lawyers and people like Jason and the other people in our network and people that we are affiliated with around the country. We have very good relationships with the Texas, for example, construction law, Tennessee, New York. We know many of these people for 40 years, have a tremendous database with the tens of thousands of contractors and lawyers that we've been dealing with and bonding companies. So we feel very fortunate. We want to share this experience and opportunity with you to the extent you need it, or work with your professional counsel anytime you need help for you locally or out of state. So thank you very much for attending. And don't forget, you have a lien right by operation of law. Don't mess it up.
I wanted to thank both Jason and Hal for attending today and sharing all this information. Unfortunately, there's quite a few questions that we didn't get to, but please feel free to reach out to NLB and Mechanics Lien. Hal, just to wrap up, before we say our goodbyes, what are the next steps? How do they contact you? How do they find it? How do they engage?
Well, it's basically very simple because, again, our project data sheet begins the process. And when you have a contract and you're reviewing it and you need help, if you're a supplier, we provide for you the blanket of information that you need to protect you on one state or all 50 states in public, private, or federal jobs. And we work every day with our notice services, and we basically team up and collaborate with our team to provide you the information and resources you need. And the questions that you have, are the questions in writing, Anatoly, whatever, but you have those?
Yes.
Yeah,
yes,
so we'll try to get back to everybody basically on the questions that they have one-on-one, or again, 800-432-7799, mechanicslien.com. It's been in existence. Mechanicslien.com has been in existence since 1999. I remember sitting in the basement with my son when the internet was like beeping and squeaking and doing things. Somehow we figured out what that name was. And it's also paymentbond.com and milleract.com. So all that information is a conglomerate of the years and years and years of information that we've gathered, and all this is available to you for resources, and we're happy to assist. And it all starts with a project data sheet. Just fill one out. If you have a question, even if it's that situation in California about the HVAC, fraudulent wire transfer, or trust fund laws in Colorado, you start with a claim form that gives us the basis. We need that information for the exact reasons like Jason mentioned. When we have the data and the information to start with, we then begin to forensically put together the pieces of the puzzle. And we're generally efficient and affordable. I mean, litigation by its name sake is very inefficient, but I have an allergy to that. So our job is to try to figure out ways to get around that. And if we can't get around it, Jason and other counsel around the country are really good at it. And we're able to help you. But 99.7% of cases settle. So for some reason, all that litigation and magic, results in some sort of settlement at some point.
Perfect. Hal, Jason, thank you very much. We got a lot of thank yous from the audience. We got a lot of questions answered, and everyone's looking forward to connecting and actually addressing their specific issues. So thank you again for sharing.
One thing I want to remind everybody really quickly is we're going to go for the next 12 months. You're going to get an agenda and a program about how the Mechanical Lien Institute part of our organization is going to keep you informed. So you'll have plenty of time to learn, and we can help you with your resources through either the videotape or one-on-one consultations, that you may need as well. And anybody who needs help, we'll bring in, Jason for Florida and other people around the country. So thank you.
Perfect, thank you. And an email is going to be circulated with the data sheet as well as other resources and Jason's presentation and so forth shortly. Thank you very much, everyone.
Thank you.
Thank you.
Take care.